Jonathan Pollard, Florida employment lawyer. I'm going to give everybody kind of an update on what I'm working on, what I'm rocking with, what's on the horizon. So about a year and a half ago, I made the decision to switch our focus from defending high stakes non-compete and trade secret cases to prosecuting traditional plaintiff side employment cases. I've done employment law for well over a decade, but was more focused on the non-compete trade secrets arena and sorted out, some long-standing shenanigans on that front and corruption and judicial activism and everything else and non-compete abuse and antitrust, right? And now I've moved into plaintiff side employment cases. And why have I done that? Well, the non-compete and trade secret cases were so big and complex and high stakes, but they never really gave us a straight shot to the dome against corporate America. Now, we did have non-compete and trade secret cases where the other side started the case and we wound up tapping them out for $1 million or even $2 million, plus got out of the non-compete, right? So that was pretty epic. But we still never got the real clear shot to the dome for $5 or $10 or $20 million. And we were always fighting with one hand tied behind our back because we'd go on offense, we would take the fight to them, but we were still, analytically, we were on the defensive side of it. Yeah, we were aggressive. We played offense even while being, defense. But we never really got the real kill shot, proverbially. And so I wanted the kill shot. And I did enough work in the non-compete and trade secret space, and I felt like, I made a significant dent in that problem. And I was a key driver of the reform efforts that you see unfolding in America today. What the FTC is talking about, I was talking about that 13 years ago. I was on PBS NewsHour, NPR, Bloomberg, Funfire, wherever you look, I was out there talking about non-compete abuse, writing about non-compete abuse, and, going the ultimate, which is like, hey, this is an echo of slavery and the civil rights movement, and it's regionalized, and it's the South violating federal law again. Wow, wouldn't you know it? The Western states where slavery was illegal don't have non-compete abuse problems. Isn't this all very interesting? Sorry to have a little fight in the middle of your non-compete party. But now I'm doing the plaintiff side employment cases. And so I pivoted to that. I had to invest millions of dollars, literally millions of dollars, in flipping the model and acquiring all those cases, all those plaintiff side employment cases, because the only way you do this, if you really want to cook, is you have to get hundreds, if not thousands, of potential cases, because most plaintiff side employment grievances are exactly that. They're just workplace grievances. I wrote an article that was in Business Insider a couple months ago about the distinction between an actual legal claim where your rights have been violated and a workplace grievance because your feelings have been hurt. And I'm sorry to be a bald-headed, jerk-faced meanie, but I don't care if your feelings got hurt, but your rights didn't get violated. I know, right? Really terrible, mean thing for me to say, but if you look at it at a meta level, right? Feelings are subject to, such squishiness, and it's so nebulous, and you can't go about protecting everybody's feelings. But as a society, you can say, hey, there are certain rights that we all have that we can agree upon, and we can protect and uphold those rights. So that's what I'm about, all right? But you have to get thousands of cases and inquiries because you have to be able to screen through these, reject 97% plus, and then just take the cases that check all the boxes and are outright bangers. This is an entirely different model than the vast majority of plaintiff side employment law firms today, because most plaintiff side employment law firms that I'm familiar with run primarily settlement mills. They take whatever cases they can get, they go through the EEOC song and dance, They go through EEOC mediation because it's free, right? Keyword, anything that's free, they're going to avail themselves of. And then they try to get $5,000 or $10,000, right? And they take their cut. That's a very typical model. We're the opposite. We're looking for cases that we can commit to, that we can invest in, and that we can take the distance and even go to trial if necessary. So typically and historically, when you're in a plaintiff side employment case, the default there is begging corporate America for some money, right? Willing to do the song and dance, engage in negotiations where the company, the insurance carrier, the corporate defense lawyer, they're going to lowball, right? Go into mediation. Take a case that I say is worth at least $600,000, And they come in and they say, our offer is $8,000, right? Liability, clear cut. You want to fight about damages? We can fight about damages. But if liability is clear cut, then you're paying your attorney's fees to litigate the case, and you're losing, and you're paying my attorney's fees for having litigated the case. So on what planet does it make sense to go into mediation and say $8,000 is our opening offer? Shenanigans. But that's the kind of dog shit that has been permitted and even invited over the past 30 or 40 years by the plaintiff side employment bar, because they're desperate to get a couple dollars. They're desperate to get $10,000 or $20,000 or $30,000, right? And go home, okay? That's not what I'm doing. That's not what I spent $2 or $3 million to go do, right, homie? Okay? I ain't here. What you think I rap for? To push a fucking rap for? Okay? No, that's not why I did this, son. I did this to really get it in, okay? And so rather than me and my colleagues going to the other side and basically begging for chump change and being willing to engage in these bad faith negotiations and this corporate posturing, you know what we do? We basically say, here's the number, okay? Here's the number. The number is the number, right? Say it with me. The number is the number, okay? Now, caveat, right? You got to keep up. If you're not smart enough, you won't understand any of this. But there are some people who watch this who are like, shit, I know what Pollard's talking about. This makes perfect sense. There's a difference between being desperate for whatever money you can get and being willing to settle for whatever you can get and going in and saying, no, here's the number. Here's what we say the case is worth. And if you have an incredibly high degree of selectivity, if you only take cases that you really believe in and are truly committed to, you can do that. Will there be exceptions? Yes, there will be exceptions. What's the biggest exception? Clients who lie to you, okay? Not supposed to say that in this business, right? It's not folksy and old-timey and collegial enough, right? It shows people how the sausage is made. It removes the song and dance, the smoke and mirrors, but that's the reality. Clients will lie to you invariably. You do enough cases, you represent enough clients, you're in the game for long enough, clients will lie to you. That's a significant factor. Client didn't tell you all the facts, didn't tell you the truth, covered something up. Okay. Covered up something that's detrimental to the case. Okay. That's a case you have to settle. You have to get out of. Case is not as strong as it originally appeared. That happens, right? That's the reality of the business, the nature of the beast. Okay. But those are exceptions. You set that aside. The longer you do this, the better you get, the more judgment and discernment that you develop, right? That is the hallmark of an outstanding lawyer, judgment and discernment, okay? And part of that is evaluating people and assessing character, okay? So you eventually get a lot better at that selectivity matrix. And so yes, you'll have outliers here or there, one off, two off, exceptions to the rule, where a client lies to you and you get screwed and you have to settle the case for whatever you can get. But those are exceptions. So on the whole, you have the ability to just ride high. You have the ability to get into a case and tell the other side, look, we demanded $800,000, okay? That's what we want. We want $800,000. We're not settling. We're not negotiating. you can just pay the $800,000. You can pay now or you can pay more later. Because if you don't pay the $800,000 by X, it's going to be more. And that's the model that we are aspiring to rock with. Now, is there some attrition? Absolutely, because client gets faced with a $600,000 offer, a lot of money, Client might turn their key and say, you know what, it's too much, I just got to accept it. Okay, and that's their right. That's their right. Or they can follow my guidance, which many of them do, and they can commit to continuing the process, trust the process, until we get whatever the dollar amount that I put on the case is. Now let's talk about that. Right? What I'm doing is some next level shit, right? If I just wanted to go make money by being a muckety muck and living like these muckety mucks and doing what these muckety mucks do and being one of them or having to tolerate them or abide them, right? There are all kinds of ways I could have made money, okay? But that's not what this is about, It's about all of it. It's about the system. It's about the lies, the con artists, the machinations, the corruption, the insurance company myth-making, big law, corporate America and all their shenanigans, and about the money, and about proving that I'm smarter than 99.9% of people in the game. That's what it's about, right? That's what I consider sport, okay? Am I a psychopath? I love people too much to be classified as a psychopath, but I'm out there, right? I'm on some other level shit. A core piece of what I'm trying to prove here is that, one, the law is a shell game, largely. It's a shell game. It's a crapshoot, It's riddled with corruption, dysfunction, everything else, okay? The deck is stacked against poor, working, regular people, right? And in favor of big companies and insurance carriers. Not only is the deck stacked, but the defense bar, insurance carriers, corporate America, they have done such a good job of myth-making and creating all of these lies and narratives, right? And they funnel billions of dollars into this, right? And you hear it all the time. Nuclear verdict, right? Nuclear verdict is just a company and an insurance carrier lowballed and fooled around where the plaintiff's claim was legitimate and worth a ton of money. And the company, the insurance carrier, the lawyer probably engaged in a bunch of shenanigans, lie, cheat, steal, cover up, destroy evidence, right? And somebody on the other side was willing to stand up to that and to go the distance for 3 or 4 years and finally get to a jury. And a jury tagged them for what was egregious behavior, right? Doesn't sound that crazy, Doesn't sound that crazy, right? Nuclear verdict, okay? Guy gets paralyzed for life in a workplace accident because the company was too sloppy and negligent to properly maintain a piece of equipment that would have required a $100 fix, right? And they knew about the problem. They knew the equipment was malfunctioning for years, never did anything about it. And then boom, massive tragic accident happens. Guy's paralyzed for life. And the company says, oh, we'll offer you $500,000, right? We'll offer you $1 million. It's big money, $1 million, right? $1 million for being paralyzed for life as a result of the company's clear and blatant negligence, recklessness. $1 million is a lot of money, right? As they're rejected, goes to trial, jury comes back, gives you $100 million, right? And they call that a nuclear verdict, right? I call that egregious, blatant corporate recklessness destroyed a human being's life, right? That's what I call it, okay? But they make that myth. They call it a nuclear verdict, right? Be scared of it. Nuclear, be scared of it, right? Got to rein in these verdicts, right? They already own half the politicians in America. They own a substantial amount of judges in America, okay? But it's not enough. They always want more. They always want more. So there's the nuclear verdict myth. There's also the garden variety emotional distress, right? I hear this all the time. I even hear this by mediators. I hear this from all sorts of people who supposedly know the law. They say, oh, garden variety emotional distress. It's only worth maybe $30,000. Garden variety emotional distress. What is garden variety about, say, a race discrimination situation where you're working on a construction site and your supervisor every single day calls you N-word this, N-word that, dumb N-word. If this was slavery times, I could whip you, boy, right? What is that garden variety? Is that garden variety? There's nothing garden variety about that, number one. Number two, I'm talking about 42 U.S.C. 1981, the original Civil Rights Act of 1865 from the back end of the Civil War, right? Nothing in the text of 42 U.S.C. 1981 says anything about caps or limitations, okay? There are no caps or limitations. There is no garden variety theory. You know how many 1981 cases there are out there where corporate defendants who engaged in blatant racism have gotten tagged for $1 million or millions of dollars? These cases are pretty widespread, right? So you hear all the time, we'll be pursuing a 1981 case, and the opposing lawyer or some mediator will say, oh, garden variety emotional distress. Garden variety emotional distress. You're just mouthing an insurance carrier big law defense bar myth. It's all hogwash. It's gobbledygook. It's make-believe, right? The other ultimate thing I want to prove, that I want to dispel, that I want to rip apart, is this notion that a person's dignity is based on how much money they make. It's bullshit. A person's dignity exists and is valuable and matters, and what that person makes or earns has no bearing whatsoever on the importance of their dignity. And yet, in every one of these cases involving a poor or working class person, corporate America and their defense lawyers say to me, well, the guy was only making $15 an hour, or the guy was only making $17 an hour. What kind of damages could he have, right? Lost his job, was out of work for a little while, It's what, $20,000? Guy's got no damages. Got no damages, right? When the original Civil Rights Act was passed in 1865, we're talking about 42 U.S.C. 1981, that was about more than just dollars. When Title VII was passed, weak paper tiger though it is, Title VII was about more than just dollars. Read the flippin' legislative history. The legislative history makes clear it was about dignity. It was about dignity. And that's what a big piece of this is. That's what I'm working on. I want the powers that be to recognize. I want corporate America, the insurance companies, big law. I want all these people to recognize that you cannot value a claim, you cannot value a case, and you cannot value a person's dignity based in any way on what that person's income is. And in fact, The counter, to go even further, you show me somebody who is out there working as a concrete finisher for $18 an hour, breaking his back in the 90-degree Florida heat every day, and getting called every racist name in the book day after day, right? I would say that person, okay, who has to work that job to survive, who has to live like that because they do not have very many other options. I would say that this person's dignity and protecting this person's dignity while recognizing all of the indignities they must suffer in this life as a result of being poor. I would say recognizing and protecting this person's dignity takes on an even greater societal significance and importance. And I would say that when a company attacks this person's dignity, assails this person's dignity, treats them as less than human, I would say that the average jury, especially in the locations where I have strategically decided to try these cases, is going to put a very high value on the company stripping away that dignity. And the value that the jury will put on that abuse and that dignity stripping behavior will be massive and completely untethered to any hourly wage. But I don't work in big law. Nobody pays me a salary, son. I'm not a house Negro. I'm a field hand. I'm a flight risk. It's different, right? It's different. Y'all do this. You sit in your ivory tower, right? Nice and comfortable. Got big names behind you, big firm, hundreds of years old, legacy, etc. You got lots of barriers and obstacles and shields to hide behind. Me, I'm out here, bro. I'm out here. Got me and my colleagues. We're out here, right? Just a rogue band of justice seekers and crusaders. We're out here doing it, right? So I don't want to hear anybody talk at me and tell me how it goes or how it's going to be or what I should do or what I should think, right? Don't talk at me unless you put $2 or $3 million of your own money in to do this, right? I don't want to hear it. Can't talk at me. Nobody can talk at me. They haven't done this, right? It's like Jay-Z said, everybody's going to try to tell you how to do it. They never did it, right? Nobody ever did this. But just watch the space. 6 months till the epic.